Good afternoon, everyone. This is Kelman speaking.
Yep.
We'll give it another minute or so. We have approximately 125 registered attendees, and as of now, there's 47 that have jumped in. So we'll give it another minute, and then we'll start the program. So just bear with us. During the course of this webinar, there should be a screen that you could see and a drop down for questions. So if something comes up during the course of this seminar and you would like to ask a question, go ahead and type that in, and we will try to get to that during the presentation. If not, then we will follow up with you.
Then following the presentation, we will be sending out a link with the webinar presentation itself and a recording of the presentation. So you get all the slides, recording about an hour after we're done, around 2:30.
You get to come back again and again and again. All right, why don't we get started here? Well, good afternoon, everyone. My name is Kelman. I am a partner at the law firm of Cohen Seglias and shareholder actually of the firm. And at this moment, I am trying to get my screen to work, so bear with me. There we go. That's a picture of me. I have been a partner at Cohen Seglias for a number of years and practicing construction law for close to 20 years. My clients range from the design builder and a developer down through the finished trades, and we represent, and the firm represents all along that food chain, handling everything from negotiations on contracts, drafting of the contracts, to claims themselves. Our office in Philadelphia is the home base. The construction practice group, however, is the second largest east of the Mississippi, and depending upon the numbers and the moment, the fourth or fifth largest in the United States. Matt?
So I am a colleague of Lane's. I'm an associate at Cohen Seglias. I've been here for 4.5 years at this point, practicing construction law for those 4.5 years in their entirety. I've worked with Lane on many cases, representing all varieties of project participants, anything from the general contractor down to specialty subcontractors, owners, and designers. So as Lane said, we handle more or less all construction matters at all points throughout a project. That is our expertise, that is our specialty, and that is what we like to talk about, and that's what we'll be talking about today.
So while we've handled almost everything over the course of practicing construction law, the one thing I have not seen is the current environment because of the coronavirus. The pandemic actually hit and impacted the world and in turn our industry. So we're going to spend some time today talking about those impacts. We're going to start with some basics. Before we even get there, we have a number of people that are online now, about 64 people. I hope everyone is doing well in this environment as well as their families. That's the most important thing. We want to go through some basic concepts first, because the basic concepts tie into the end, which is what are we doing now in the current environment because of the impacts arising from the coronavirus. So to understand the what we do, you have to understand the basics and some terms of art. So we're going to walk through the types of delays that are arising from COVID-19, discuss what is a construction delay from a basic perspective. From there, flow to contract clauses. That's not intended to be an all-encompassing contract clause overview, but some important ones that you should be aware of and focus in upon. And then lastly, we'll talk about strategies to address those impacts.
So just to begin with, let's talk about the big elephant in the room, the actual COVID-19 shutdown in Pennsylvania. On March 20th, 2020, roughly a month and a half ago, nearly all construction activities in Pennsylvania were required to cease by order of the governor. This applied to everything aside from some emergency work and some securing of the site. The order went into effect March 21st, and it continued all the way up until last Friday, which was May 1st, 2020. Interestingly, it was 40 days. The Latin term quarantine actually means 40 days and 40 nights. So we did have a quarantine of construction, if you will. And then on May 1st, Friday, construction activities resumed, but they resumed under certain conditions in Pennsylvania. These conditions include a mandatory 6-foot distancing between all projects, everyone on the project. There are certain limitations as far as how many people can be on certain projects. If a project is 20,000 square feet of enclosed space, there can be no more than 4 people in that space. And then I believe for every 500 additional square feet, one additional person can participate. Any employees that show symptoms of COVID need to be removed from the project and put into a quarantine. PPE, which is personal protective gear, needs to be required by everyone on site, including the masks. I'm sure everyone has their own masks at this point. There needs to be cleaning stations located throughout every project where the lunch station is, where the lunch trucks are, where the break stations are, any field offices all need to have locations where employees and workers can clean their hands. And then finally, a site safety director to make sure all of these guidelines are being followed needs to be put in place, whose primary responsibility is to walk the site consistently and keep tabs on that. I note that if a project is not following these guidelines, or rather requirements, anyone can put in an anonymous complaint to the state of Pennsylvania, and I believe the Department of Labor will come to investigate if a complaint says that these guidelines, or rather these restrictions, are not being followed. So with all these in place, we've already seen a time impact of a month and a half because of the shutdown. But now that construction is resuming with these restrictions, we're necessarily going to see inefficiencies in the work proceeding. And of course, because of the month and a half delay, all completion time we anticipate will be pushed back to some degree. So what are the potential costs that we're looking at just to begin with? Well, because of the inefficient work, expecting additional man hours, it's going to require more people out there for longer periods of time to complete the work that otherwise would have taken less time. You're going to have to pay the person who is monitoring the health on site, the supervisor for that. PPE, that's all going to have to be provided as well. Sanitizer, masks, all that equipment. Owners who have their projects delivered late can expect lost revenue for one, and then additional financing costs potentially. And then finally, because we had at least a month and a half of complete shutdown or near complete shutdown, there was no revenue being generated for contractors to pay for their home office expenses. So we have unabsorbed home office overhead for a period of at least a month and a half. The question on everybody's mind is who should pay for these costs? But before we get there, as Lane said, we need to take into account some fundamental concepts about delays in construction. So we're going to dive into that. And I will say too, Lane and I had originally intended to present this in March through the BIA prior to the quarantine impacts. This was canceled and put on hiatus because of the impacts, but quarantine and the COVID ties in perfectly to construction delays. And obviously you'll see why if you don't already know. To begin with, I prefer to use the term time impact rather than delay. Delay is sort of the status quo when talking about anything that's going to impact the project schedule. However, not all time impacts are necessarily delays. Of course, if the final completion date or the substantial completion date are delayed and delivered later than they are required to be in the contract, that is no doubt a delay. However, inefficient work that's proceeding at half the pace that it was anticipated, work that's accelerated, whether that's by order of an owner to a general contractor or a general contractor to a subcontractor, is the opposite of a delay. It's making up for lost time. It's going at a quicker pace. There's total stoppages of work, like we saw with the shutdown from March to May. And then the time impacts are not just limited to one of these instances. It could be a total combination of all these different types of time impacts, including acceleration to make up for inefficiencies, acceleration to make up for a pushback delivery date, acceleration to make up for a total stoppage. So for that reason, time impact is the preferred term, at least from an attorney standpoint. To put all these
the courts will interpret a time impact as an impact that is arising from delay, and that is why the term delay damage or delay is applied to time impacts as a general label.
So to illustrate all these different types of impacts, Lane and I came up with a hypothetical scenario that is based on very real time impacts we have seen in different projects and in different cases. So to begin with, let's say there's a project that is expected to commence on January 1st, 2020, and the contract requires substantial completion by March 31st. Contractor works through February on schedule, and in March, the middle of March, we hit an oil tank underground that was unexpected, didn't show up on any reports, and the soil is contaminated. Suddenly, there's an additional component of work. The tank needs to be removed, clean dirt needs to be brought in, and this excavation work is going to affect the critical path, which is the path from the start to the finish of the project. It's going to push it back by half a month. So immediately we're looking at a potential time impact, delaying the completion, as well as increased costs to both the owner and the contractor.
The example Matt just gave has to be contrasted with the next example, because the example Matt gave is limited potentially to just one or few trades. You have the excavation trade, then perhaps you have the foundation underground work. But that delay to the project can be mitigated by resequencing, claiming float, etc. But you nonetheless do have a critical path delay to the excavator and, for purposes of the discussion, the foundation contractor. But the delay to the project can be avoided. With COVID-19, we have out of the box a 6-week, for purposes of discussion, 6-week delay arising from just the suspension. So using that as a 6-week delay period as an example, you have a project that is entirely shut down until May 1. Completion is pushed to July 1st. That is a delay based purely upon the 6-week period. The impact to the owner is, of course, late delivery of the project and all the financial implications that flow from that. Impact to the contractor, general conditions, escalations, productivity, unabsorbed home office overhead, etc. That's simply from the suspension and delay period. However, once there's remobilization, it's going to be potentially a lot more than that, as we all know. Sorry, trying to get the screen to work here. When work resumes in May, though, as in now, there's certain restrictions that are in place. Those restrictions right off the bat have a cost associated with them, whether it be new equipment, whether it have the safety officer, or probably much more so from a dollar standpoint, sorry about that, you're going to have a productivity impact. You have fewer men on site. You're going to have, in addition to fewer men on site, you're going to have work that's not linear in fashion, and you're going to be going from what would have been 1 month of work to take 2 months of work. So because of that, so you have a suspension of work, which is 6 weeks, and then because of the lack of productivity, because of the new conditions, you're going from 1 month to 2 months. That 2 month period is an additional, that 1 month in additional work is a delay period. That's over and above the suspension. So by the end of June, because of the new schedule that's in place, you're looking at a September 1st completion date. Sorry for the delay here. When you hit that September, when you're looking out though and updating, all of a sudden on July 1st, certain restrictions are lifted. That restriction allows for greater productivity. As a result of that, the owner directs for there to be acceleration to try to achieve a July completion date. So you take what was supposed to be based upon coming out of the suspension, a 2-month duration, you then trim that 2-month duration by 1 month because of acceleration. So through that little example, you have all forms of impacts. You have the original 1-month extension of work or extension of the construction duration. You have the suspension of work. You have inefficiencies arising from the lack of productivity. That is, you couldn't have the manpower in a sequence that you wanted. You have acceleration because the owner wanted to bring this in by July once the restrictions were lifted, but you still nonetheless have a late completion because of the impacts arising from the shutdown. That, of course, implicates a lot of extra costs. You have extended general conditions because of the extended duration. You have the man hours that are flowing from the acceleration and the inefficiencies related to resequencing, smaller crews, etc. And then you have on the back end, liquidated damages, lost profits, financing, and unabsorbed home office overhead. So it's important to understand all the different types of impacts that can arise from the coronavirus. And we'll talk more about those from a contract perspective, but also from how to hopefully manage those and document those.
So let's hone in on claims specifically from an owner versus a contractor. And similarly, this could be from a general contractor pushed down towards a subcontractor. These are generally simple. If you have a contract that requires completion by a certain date of the project, and it says time is of the essence, that is now a contract term. If the contractor doesn't meet substantial completion by that deadline, the contractor has, on its face, breached the contract. Now, with that being said, an owner cannot recover damages for that breach, and it's not a breach to begin with, if the delay by the contractor is either excusable or a concurrent delay with the owner. What are those two things? Well, an excusable delay is a delay outside the contractor's control. For example, a government-wide or statewide ordered shutdown of construction by the government would generally be an excusable delay under most types of contracts. And then a concurrent delay would be a delay caused by the contractor simultaneously with the delay caused by the owner that net each other out. The contractor is responsible for 2 weeks of delay, owner is responsible for 2 weeks of delay. They cancel each other out in most circumstances. If the project is not completed by the deadline in the contract, the contractor bears the burden of showing that it was not responsible for the delay, or alternatively, the delay was excusable. So if it is delayed, let's say you have a project that's going to be delayed by a month and a half, an owner wants to bring a claim, a contractor can rebut that by showing that a month and a half resulted from government shutdown. What are the damages that an owner can recover? Well, there's a laundry list, and we'll talk about a little these in more detail at different points. But to begin with, if there's a liquidated damage clause in the contract that says for every day late, contractor shall pay owner X amount of money per day, that is generally a easy measure of damages, generally enforceable. If there's no liquidated damage clause, the owner could seek potentially lost profits from not having the project delivered on time, seek financing costs for having to continue to finance the project until completion, until it starts generating a revenue. If the owner has a representative on site that is paying, and that representative is out there more often, those additional costs. And then a potpourri of different other potential damages, for example, displacement of tenants. We had a client once who had to put tenants up on a hotel till the project was completed. would be another potential cost. Aside from liquidated damages, any of these need to have a reasonable basis for their calculation, and the contractor must have been aware about the possibility of these damages arising at the time of contracting. If the owner was building a residential house, for example, not a great example, but the contractor wasn't aware that the owner intended to rent it out, that might strike out the possibility of recovering for displacement of tenants, because it was never an idea, sort of that came into the party's bargain.
We'll expound more upon the owner-related damages as we delve further into this presentation, but there's some important components, particularly from an owner, because the ability to recover damages is a little bit more difficult because of the concept of direct damages and consequential damages. So generally speaking, it is our counsel that if you're an owner or developer, to attempt to calculate liquidated damages and put those within your contract, because otherwise it becomes much more difficult to prove out the direct damages and recover. Lost profits, financing costs, those become perhaps speculative and subject to a lot of other factors to put on the shoulders of a contractor in the event of a breach. From the other perspective, of course, you have the claims of a contractor versus owner. And the contractor versus owner claims oftentimes are bottling up downstream claims as well. That is the subcontractor impacts and flowing those through the general contractor. As Matt said and alluded to earlier, the time impact must be compensable. So what does that mean? Weather is generally, W-E-A-T-H-E-R, weather is generally non-compensable. So if there's a lost weather day and you lose 5 days a month, and that turns out to impact the project's completion by a month and a half, that is lost time where you only get time. That is, it's excusable time and is not compensable. The exception being if the contract says otherwise. The contractor must, if the contract requires it, and even if it doesn't, it's highly recommended that you do, put the owner on notice of the time impact. Contractors should reserve rights and not waive claims. And typically, whenever there is a time impact claim, you should have a scheduling expert behind that claim that is doing the schedule analysis. And we'll dive into all these bullet points a little bit more. There's different types of impacts, as we tried to demonstrate through that second example. You have the extension of the project itself, you have the stoppage, you have acceleration, inefficiencies, and oftentimes combination of the above, if not more, such as cumulative impact. Those are all different impacts that are time related. But in order for there to be a delay claim, you have to have a delay claim that is based upon a critical path analysis. So the first example that Matt put up there about the excavation contractor running into bad soils and having to bring in new soils to achieve compaction, that is a critical path activity. And we differentiated at the outset between the impact on the excavation or excavator and the foundation contractor and the underground work, because that critical path ran through there. But at the end of the day, there might not be, because of mitigation, a delay to the project itself. So it has to be, if you're making a claim for delay, the delay has to run through the critical path. Of course, the COVID shutdown, there's a project shutdown. So the project-wide, there is a delay. But we'll talk a little bit more about what happens if there is a delay that pushes the project into a suspension period like we just experienced. The delay must affect the critical path in order to be compensable, as opposed to the weather, which is non-compensable typically. So as we talked earlier, you have extended general conditions. That's a time-related impact because of delay. General conditions, project management, field management, vehicles, rental equipment, whatever it may be that is actually in the field. You're going to have also potentially increase in material and labor costs. This suspension that we just experienced and the delay that we are experiencing right now pushed us into May. Projects a number of them undoubtedly would have and should have been completed prior to May 1. May 1 is a magic date in Philadelphia for a lot of trades, union trades, because then there's a wage escalation that now is going to have to be absorbed. And the question becomes, who absorbs that? Material storage because of the shutdown. Who bears the cost of that? You have a lot of materials that have to be protected. That's additional cost. So what is the difference between delay and the implications of a delay versus a stop work order? Well, stop work order, of course, the project as a whole is suspended, but you also have to be prepared to resume work upon notice from the owner. That would result in a suspension of time, and also potentially, depending upon the cause, you have a lost home office or unabsorbed home office overhead calculation. Now, the additional cost, as well as that we did not talk about, you have a demote cost and a remote cost. Where is that captured? Is it captured? Those are all arising from a stoppage of work. Once work resumes, you have inefficiencies. Those inefficiencies are going to be flowing from restrictions as well as job site conditions that were not and could not have been anticipated by anyone. And there's emphasis there as to could not have been anticipated by anyone. That's going to result in additional man hours. Now, it's incumbent upon contractors to capture those additional man hours. At the end of the day, you may be upside down by 50,000 man hours, but if you can't show, other than a total labor hour calculation, where those man hours were incurred, how, it becomes a little bit more difficult to prove out those damages. There's a number of different methods that are approved by the court, and there's a hierarchy of preference of those methods. So the more detail you keep, the more likelihood, the higher the likelihood it will be that you'll be able to prove out those damages.
Lane, if I can add to that, that's a hugely important part of proving acceleration, or excuse me, well, both acceleration and inefficiency, is the quality of your estimating. You have very detailed estimating with the amount of expected labor hours it's going to take for each individual component or item of work. That is going to be a lot easier to prove acceleration or inefficiency rather than if you're doing a total cost method and taking kind of very loose estimates for your different items, or just doing the project as a whole. So,
yeah, so to just add a layer to that, what the benefit of having a detailed activity by activity labor breakdown from an estimate perspective is only as good as how you capture those costs moving forward. So if you have a manpower loaded schedule, you have cost codes for each activity, and you're tracking those costs, and you understand that on May 1st, 2020, you remobilized on the 5th floor, and you were running conduit on the 5th floor, and you're able to compare the conduit run on the 5th floor compared to what you did on the 6th floor back in March when you had the full manpower in place, then you're going to be able to measure out your damages a lot more readily than simply looking at what your estimate was and then your total manpower or labor on top of that. That's a lost productivity approach. Lost productivity can arise from a direction to accelerate, but there's also additional cost on top of the acceleration direction. You're going to have lost productivity, but you're also going to have an additional lost productivity. You're going to have more expensive man hours that is working overtime, PTOT. That's going to cost, if you're a union contractor, additional dollars. And in addition to that, you're going to have the man hours themselves. So you're going to go from a budget of 50,000 man hours to hitting 100,000 man hours, or whatever the case may be. So that's going to have a cost. Again, capturing those costs, understanding capturing the direction to accelerate, capturing those hours that were accelerated is all very important. Sorry, trying to get the screen to move on here. There we go. Once you get down to, once you get down to all the costs, you're then going to get caught up in the prosecution defense of those costs. But before we get there, there's contract clauses that are going to be implicated, and Matt's going to give an overview of those.
Sure. So this is, I will say, Lane and I are not in the same location, if that's not apparent, and we both have joint control over the PowerPoint, so it's certainly a learning process for presentations. So as Lane said, we're going to get into the actual clauses. You know, there's general rules for delay recovery and time impact recovery created by the courts, but everything is going to be viewed in light of what your contract actually says. So probably the most important thing that you need to look at after this presentation if you're considering delay damages. Most important clause, and one I spent way too much time looking at as a young construction attorney, is the no damage for delay clause. It's generally a standard clause that's used in almost every state throughout the industry, and it essentially says that if there is a delay on the project, a contractor or a subcontractor is only entitled to an extension of time and cannot recover any damages from an owner, even if it's the owner's fault. The clauses typically say. It says it doesn't matter if it's the owner's fault. It doesn't matter if it's a COVID-19 shutdown, an act of God, war. The only thing that a contractor is entitled to is time. Now, I'd say these are probably maybe half the contracts we look at. I note that the AIA A201 does not include a no damages for delay clause, but if you're operating under a modified AIA, you might have it. And these are generally enforceable. However, no matter what state you're in, there is almost guaranteed to be an exception. And those exceptions, at least in Pennsylvania, are caused by occur when the owner has either actively interfered with the work of a contractor or the owner has failed to take necessary action to progress the project. What do those things actually mean? Well, design changes, design errors, failure to provide site access, or failure to coordinate contractors if it's a multi-prime job, like most public jobs are, school district jobs that come to mind immediately. Those are all examples of failure to provide site access. One case that active interference or failure to take necessary action. One case that jumps to mind immediately, a contractor was going to do excavation work, and they came to the job site and it was totally flooded, and the owner had never actually arranged for a drainage of the site prior to the contractor starting work. And a court set aside the no damages for delay clause and said this is an owner's active interference and failure to take necessary action.
So while Matt said that the delay clauses are generally enforceable, that is true, but they are also, at this point, extremely watered down. And if you're in the construction industry, particularly if you're in New Jersey or Pennsylvania and you're confronted with a no damage for delay defense, then you're just pushing that aside because the exceptions are so broad. And the exceptions are really rooted in the idea that it is inequitable to have the contractor bear the cost for a condition that's created by something that the owner can control, avoid, and mitigate. So at the end of the day, if you can link the delay to something that the owner can control or should have controlled, then there's going to be a gaping hole in the no damage for delay defense. And I have yet to see in Pennsylvania and New Jersey in recent years where there's a decision that's made that says, hey, your claim here for delay is null, or not null, but it's accepted out and waived by the no damage for delay clause. They're very watered down. Some states, they are outright void as a matter of law. Other states, the restrictions are not quite as broad as the tri-state area. And in New York, you have to do certain liquidating agreements and whatnot to get them passed through.
So with that said, while there are certainly exceptions in almost every state for owner interference, I am not aware of any exception yet for acts of God or things outside of the owner's control. Weather is a good example. So I said acts of God, a labor strike, or a pandemic. That doesn't mean necessarily that that clause would be enforceable to preclude recovery of any of these, of delay damages in the event of any of these events. However, it has not yet been addressed as far as I'm aware, and I'm sure that somebody will challenge a no damage for delay clause as a result of the pandemic in a creative way. So I talked about a liquidated damage clause earlier. Just to dive into this a little more specifically, a liquidated damage clause is a clause that benefits the owner, and specifically states that every day or month that the project is delivered late, and that is to say past the day required in the contract, there will be a monetary amount that the contractor pays to the owner, or rather is deducted from the final payment. Notably, this can't be a penalty. You can't simply put in a giant number to scare a contractor or subcontractor, but it needs to be reasonably calculated based on the actual projected losses. And that means that if it gets challenged in litigation, the owner better be able to pull up the original paperwork where they did their calculations to say, to essentially come up with a liquidated damages number. Liquidated damages need to be calculated. Go ahead, Lynn.
I have successfully challenged liquidated damage assessments because I've, during the course of discovery, focused in upon the workup and worksheets to arrive at a liquidated damage amount. And if you don't have the workup to it, then the argument is that it's punitive, it's not tied to a reasonable calculation, and then you could get that blown up. On the other hand, I work with my owner developer clients to come up with those worksheets to try to reasonably calculate what the damages may be so that there is a paper trail of that workup. And also to make sure that everything is being captured. Unfortunately, I have a client right now in DC where I was given the case pretty late in the game, was not involved in the contract negotiation end. There's a liquidated damage clause that is nowhere near capturing the damages of this owner who, where there was a completion date that was not achieved, they lost the tenant for a whole year. So there's a huge liability in one hand, there's a lack of income, and the LD clause is woefully undercalculated. So that's an extremely important tool that the owners, developers ought to be using, and it could oftentimes be counterbalanced when there's pushback by a contractor by, rather than liquidated damages only, if you achieve early completion, then what happens then? There could be a bonus. And again, that's a way to try to counterbalance a concern that the GC may have. Yeah, Matt.
Yeah, so as Lane said, they need to be calculated, they need to be a basis, and they need to be intended to compensate for expected loss based on what the owner expects to get following completion. So simply, if you're expecting $20,000 a month from a 10-unit building, you could calculate that based on, divide 20,000 by 30 days, and that looks like a reasonable basis. We need a little more than that, but that's the general idea. Moving on to another important clause in the contract, which Lane alluded to earlier, is this idea of consequential damages, and specifically a consequential damage waiver. But to understand a waiver, you need to understand what consequential damages are. So consequential damages are not direct damages under a contract. Direct damages say that owner must pay contractor X amount for completion of the project, and the contractor was not paid X amount. That X amount is the direct damages. Consequential damages, however, arise, a little further down the causal chain. For example, contractor was not paid X amount from the contract, and then contractor lost a bunch of jobs and went out of business. Loss of business, loss of reputation, that would all be a consequence of the breach of contract, the breach being the non-payment. Additional consequential damages are owners increased financing because the project was late. For example, lost tenants. And as I mentioned earlier, to recover consequential damages, the other party has to have been aware at the time of contracting that those damages were reasonably possible. Discussions about tenants or financing or whatever it might be should establish a basis that they were aware of it at the time of contracting, and they knew that if they breached, there could be a damage. Now, with that said, the consequential
on the contractor end, it comes up a lot, and I expect to see it, particularly in this environment moving forward, where a project's delayed, you're running up against your pipeline where there's other projects, and you have a bonding capacity issue, and you lose those projects because you cannot, because you don't have the bonding capacity to bond the other projects. That would be a consequential damage. Matt.
So, as mentioned, consequential damages often are addressed by waivers in the contract. They're very common, the waivers, and they're generally enforceable. I don't think I've ever seen an exception or a clause set aside in any case that I'm aware of. For example, the AIA A201 includes it just as a matter of right. And as you can see, first bullet point, it precludes the owner from recovering rental expenses, losses of use, income, profit, reputation, employee productivity. And then on the contractor side, it precludes the contractor from recovering home office overhead, right in there that we discussed earlier, along with loss of financing, business, reputation, etc. That is not an exhaustive list. That is an inclusive list, and any other consequential damage would be captured in this waiver of consequential damages. Under the next slide, we're going to talk about something very important and relevant to the COVID, which is a force majeure clause. You've probably heard this phrase in any number of emails that have gone out over the last 2 months. It is a French term that means superior force, and a force majeure event is essentially an unexpected event outside the control of both parties at the time they contracted. And a force majeure event will affect the party's ability to perform under the contract. Acts of God, war, labor strikes, or a global pandemic are all examples of force majeure events. Now, unlike many of the previous clauses we discussed, a force majeure clause is not necessarily a standardized clause. It is a condition. It essentially says that if a force majeure event occurs, then something else happens. And it can be customized to whatever the parties want to do in their contract. The A201, the AIA A201, that has a force majeure clause built in as a default, and that provides necessarily for a time extension that says that if there's a force majeure event, contractor shall be entitled to a time extension. I don't think it actually uses the term force majeure, but nevertheless it says act of God, labor strikes, etc. And I note that the A201, yes.
You're citing in the 201 here, time extension under section 8.3. There seems to be a missing word there. It doesn't say compensable. Is that correct?
It does not say compensable. However, it does not say not compensable. It's a little bit of ambiguity built into the A201. It certainly allows a time extension, but it doesn't say you can't recover for compensable delay. So it doesn't operate as a no damage for delay clause, but it simply says you get a time extension and then the parties can make claims for damage. And I know that certain skilled attorneys, such as Lane Kelman, have made successful claims for damages under section 8.3 and use that to justify compensable damage claim. Other things a force majeure clause can do, if a force majeure event happens, it could explicitly allow a party to recover additional costs because of that event. There can be price escalation clauses that occur because of force majeure. It says contractor can recover 1.5 times the amount of pricing going forward, whatever it might be. Additionally, force majeure clauses can allow parties to terminate the contract without consequences. So finally, just noted about terminating without terminating for suspension of work. The A201 provides that if there is a long suspension of work, parties, a contractor, I believe it's 60 days as a result of a government order, contractor can terminate the contract, wash his hands and be done without any consequences. That also operates under CASPA, I believe, as well. And those clauses we just discussed, I think, are the essential, core of contract clauses that you need to review in order to determine whether or not you have a valid delay claim.
All right, so this is why all 125 of you registered, right? This slide, who bears the cost of the impacts? And the good news is it depends. So there is no right or wrong. The bad news is it depends and there is no right or wrong. The answer who bears the cost is going to depend upon the circumstances. It's going to depend upon the contract. It's going to depend upon the parties. It's going to depend upon how the parties comply with the contract requirements. Bear with me a second. The question becomes, from a document standpoint, using the suspension of work for the 1.5 months as the jumping off point, no party, owner, contractor did not cause this. This is a straightforward suspension of work. So is there a suspension of work provision in your contract or not? Is there a force majeure provision in your contract or not? What does the force majeure provision say? What do those clauses discuss as far as demobilization, remobilization? What do they talk about as far as once you remobilize and you put in a recovery schedule and it's pushing out the completion date a year? How does it address material costs? Because material costs, labor escalation costs, inefficiencies, those are all going to be costs that are going to be impacting owners, contractors, and everyone downstream. So you need to understand key contract terms. You need to have mastery of those contract terms. If you're using a standard AIA 201 as the general conditions, then your exposure, if you're an owner or developer, is going to be a lot broader than if you're using your homegrown contract, hopefully. The notice requirements flow likely both ways. If you're a general contractor and you understand that there's going to be additional costs, what does the notice provision in your contract say? Likewise, if you're the owner and you're going to be passing claims downstream, what does that notice requirement say? And why is notice important? Well, if you're an owner right now and you get a notice from the general contractor that is projecting costs through a recovery schedule for another year and a half, and the project is completely upside down, you may want to terminate for convenience. You may want to get a different contractor. You may want to cancel the project. You don't know. If that contractor does not provide notice, and then 6 months in or 4 months in, it then submits a claim, the owner is going to have a great defense for saying, what the heck? We remobilized. You're supposed to provide notice. You didn't do anything like that. I'm proceeding as if costs are going to be de minimis. And yet now here you are handing me a 7-figure claim. So it's really important that the notice provisions are complied with on both ends. Likewise with the claim provisions. If you have a claim provision in your contract that's talking about how to document a time impact, and you have to do a time impact analysis in conjunction with submission of your claim, or provide a manpower loaded schedule, and you're not doing that, then you're going to have a problem. It's going to be a lot more difficult, because part of that claim provision that is requiring a time impact analysis or manpower loaded schedule is to put the owner on notice so it can make decisions. So you're going to have to overcome those type of requirements. Likewise, as we talked about earlier, you have to track costs, understand what those costs are going to be, so all parties are making informed decisions. And that again goes upstream and downstream. The owner should be doing the same. So when we're talking about the owner understanding what the costs are, there's a joint interest here, and the to-dos really do parallel one another. As a contractor, when you're remobilizing, if you haven't already, and even if you have, you should be sending out new notices. We're remobilizing. commencing work on May 8th, the conditions under which we bid under are much different now. We will track costs, we reserve our rights. You should be providing an updated project schedule to understand whether that's going to be accepted or rejected. And then from there, you could talk about those costs. And importantly, as a contractor, and this is something that comes to play all too often when Matt and I get cases and partial releases that are accompanying almost every payment requisition now. Reserve your rights. And within that reservation of rights, if there's a placeholder in the partial lien release where you should write in what the claims are or what it is you're reserving, do that. It is crucial. Conversely, the owner, when you're getting those payment applications in, make sure that your project team is looking to those partial releases. Make sure it's understanding what is being reserved and what is not. Make sure it's monitoring the correspondence that's coming in addition to those partial lien releases. Make sure during meeting minutes, or rather during project meetings, there are meeting minutes that are being taken that are memorializing what is being said and what is not. Much like the contractor should be providing an updated schedule, owner wants to know from day one, what does this recovery schedule look like? If you're holding the contractor to the original date, then you're going to be looking at acceleration costs. You're going to be looking at lost productivity costs arising from that. You want to know what those costs may be because of the new project conditions. So as an owner, you can go and make informed decisions. I would highly recommend that the project team starts meeting now with all the players to look at what the schedule looks like, to understand what those costs may be, so there are no surprises, and that you can start to work together to mitigate those costs. The reality is, contractors are going to be entitled, in all likelihood, when I say all likelihood, only because there might be some odd language in some contracts, but all likelihood, contractors are going to be entitled to some time extension. The other exception, other than particular contract language, would be if, because of delay caused by the contractor, and this is important, if delay caused by the contractor pushed the project completion date into this COVID suspension period, or pushed this project completion date into the new regulatory environment where there's going to be a productivity impact, then as an owner, I think you have a strong argument that, hey, because of your delay, this is an impact arising from what you caused. So there's arguments there. And that argument can be whittled down perhaps to a trade by trade look. Maybe the project overall was delayed because of the COVID, but certain trades would not have been, had the project gone as planned, certain trades would not have impacted had the project proceeded as planned. The contractor is going to bear the burden of showing the time impact is not their fault rather. Flip side is, as an owner, we talked about liquidated damages. The owner initially has what's called a total time calculation. That is, they show the project was delivered 48 days later than it should have. That, from a liquidated damage perspective, you then assess liquidated damages based upon those 48 days. The burden then shifts to the contractor to demonstrate that it is not liable for those 48 days in their entirety. Rather, there's some days within those period of time that the fault of the owner or are warranting extension, maybe not as a full compensable extension. Contract form here is important both in looking at the current cost and claims, but also moving forward. So what I mean by that, if this is a GMP, then in all likelihood, not all likelihood, then the added cost here we're talking about would be a cost of the work, unless you have a contract revision that defines cost of the work and accepts this out. So if there was a projected savings going into COVID, guess what? That projected savings in all likelihood is going to be eaten up. The idea of application and no damages for delay, need to have command of those, and also understanding no damages for delay provisions moving forward as you draft contracts. At the end of the, conversely, I'm going to just double back to something I just said about the form of the contract and who bears the cost. While we address the GMP, if it's a fixed price contract, the fixed price is going to be problematic. You don't have the ability to plug in these additional costs as a cost of the work. So I would recommend that as a contract mechanism, rather than as an owner, rather than negotiating a change order for these additional costs, think about negotiating an allowance and a not to exceed allowance. Cost of the work under the GMP gives you the ability to audit those costs and make sure that what is being billed as the cost of the work is actually tied into the COVID. If you just issue a blind change order to the contractor, then you're looking at if for whatever reason there's a savings on those costs, the contractor is going to accrue that benefit. If all of a sudden the job conditions change, and you're operating under this change order, that change order is in effect through, it's anticipated that project completion is not going to be from a year from now, but 6 months from now, restrictions are lifted. Contractor is going to bear the benefit of that. And if you're the owner, if it's on an allowance basis, then that's a way to even out the playing field a little bit. So moving forward, no damage for delay clauses, force majeure clauses, suspension clauses, escalation clauses. Those are all items that need to be looked at now, but also for contracts moving into the future. What your contract says is going to be applied to the facts of the project and the personalities and players that are there. There is not a one-size-fits-all. You need to hopefully be proactive and take steps now and start to manage this now. Because remember, both parties, owners, contractors, are under a legal obligation to mitigate damages. If there's things that could be done now that were not done now, then you're going to feed the other side's argument as to what the recovery should be rather than what is claimed. So with that said, take a look at your contract forms, massage them for the new reality, and I'm happy to answer questions. I do want to make one other additional remark. Our firm has put out COVID packages. When the suspension first hit, we put out a number of forms that were being utilized by clients and non-clients alike. It's a no-cost form. We published those. We then did a COVID update for when the exemptions were in play. We're doing a COVID update number 3, again, a third package of forms that are going out to all of our firm contacts. You're welcome to use those. I found it very amusing at some point when I had clients, plural, show me forms that they had received from clients and non-clients alike that our firm had created. So Matt and I are available. Our contact information is going to be made available by the firm. You have access to it. You're welcome to call us, email us, follow up in any way, form, if you have any questions or want to talk anything through. Be well, be safe, and I hope to see everyone in person very soon.
Lane, we've got a minute or two. If anyone has a question they want to ask right now, there's a question box you should be able to access. You can feel free to type it in. But if you want to ask anything privately, feel free to contact us. You have our emails, you have our cell phones. Numbers are right there. So please don't hesitate to reach out.